Hello. This video is my presentation in regards to several complaints I have concerning the Freeland Police Department. During a meeting that was held on July 7, 2016, at that time I notified the council that this video exists, its location on YouTube, and summarized its content. It was uploaded a few hours before the public meeting began. A transcript of this video can be found at www.phineas.org/freeland.html. First, I'd like to clarify my phraseology. It is customary to use phrases such as the Freeland Borough. I call the entity the Freeland Corporation since as of 9/11/1876, the borough became a municipal corporation. Also refer to a police officer as a paid corporate employee. This all stems from an incident that took place when my daughter was pulled over and issued a citation for careless driving within the land boundaries under the control of the Freeland Corporation. A few months ago, shortly after the citation was issued and before the scheduled hearing took place, I spoke at the regular monthly meeting and addressed my concerns at the intersection of Washington and South Streets, the latter also known as Route 940, had certain safety issues. It is apparent that the council agreed because shortly thereafter the road crew of the Freeland Corporation erected a convex mirror on an existing telephone pole located at the southwest corner of the intersection to aid motorists traveling north on Washington Street with better visibility as they approach the intersection. With that said, let me present a list of my complaints in no particular order. The police vehicles need dash cameras, because it is my position that if a dash cam was installed and operational at the time Officers Harris and Michaleshko pulled over my daughter, no citation would have been issued because the video would not have supported the traffic stop. Next, during a hearing before Magistrate O'Donnell, the police chief, Mr. Harris, stated under oath, also in front of an assistant district attorney of Luzerne County, who was also present at the hearing, that he obeys the law. I tend to differ because I have two videos that discredit his testimony. One video shows how he ignored a stop sign at the intersection of Washington and South Streets while traveling north on Washington Street during routine patrol, apparently headed toward the police station, and another showing him parking the police cruiser in a no parking zone adjacent to the PNC Bank at the corner of Center and Front Streets. The light bar was not activated, so it appeared there was not a crisis situation taking place. It is my speculation that Mr. Harris was at the bank to conduct private business and or arrived and entered the bank for a non-emergency. So the next question, is the officer, Mr. Harris, or any other Freeland police officer above the law? Will counsel stick their head in the sand and look the other way, make excuses? I want to file a complaint against the police chief, Mr. Harris, for actions unbecoming an officer, or by any other suitable and or descriptive label. Within a few minutes after my daughter was pulled over, I was notified by a witness observing what was taking place, and then I arrived on scene near the intersection of Center and Luzerne Streets. I was also a witness to Mr. Harris's conduct and demeanor. He was acting like a bully monster, yelling and screaming, assaulting my daughter verbally. His face was beet red with heavy sweat apparent, and he repeated twice that my daughter almost tore a friend off, quote, his vehicle. Mr. Harris's conduct was unjustified, and I request that counsel conduct an investigation. As a parent, for me to stand and watch his conduct, whereby my daughter was shaking and crying, was alarming. Also, as a parent, I was able to keep my emotions in check while watching this ghastly scene unfold, and at the same time trying to console my daughter while she was still seated in the vehicle. I would like to know what laws of physics would be needed for a small compact car traveling at 25 miles an hour to literally tear the front end off a Ford truck that had reinforced front end. During the hearing, Mr. Harris testified that the push bumper was only an ornament. I interviewed the salesman at the local car dealer where that truck was purchased, and he informed me that that particular truck was sent to a specialty garage to have the police package installed. That push bumper is also used for ramming, and it is not an ornament. Mr. Harris misrepresented the facts. That particular police truck, with its gross weight and size, including reinforcement, the combined speeds of both vehicles, approaching each other at approximately a 90-degree angle, if an accident had resulted, the vehicle my daughter was operating would have been severely damaged. It was my daughter's quick actions that avoided an accident. Mr. Harris grossly exaggerated the potential damage that could have resulted to, quote, his vehicle. And his own words can be used as evidence that he likewise exaggerated what took place. As mentioned, he also failed to accurately describe the attached push bumper. His comments suggest that he had no concern for my daughter's safety or damage to any other vehicle except the one he called his. Mr. Harris had exhibited a self-centered view of events and no doubt convinced himself that he was the victim, and no doubt worried if there was an accident with witnesses in the vicinity at the corner of Washington and South Streets, could have jeopardized his career. This might fall into the category of narcissism or projection. It is my allegation that Mr. Harris is a cowboy by the manner in which he routinely operates the police vehicle while on duty and with his accelerated speed approaching the intersection on the day and time in question, while failing to obey the stop sign, had the front end of the police vehicle partially blocking the eastbound lane of South Street while my daughter was negotiating a left-hand turn, attempting to travel south on Washington Street. Mr. Harris failed to yield the right-of-way, and my daughter had the right-of-way with no oncoming traffic in the eastbound lane of South Street while negotiating the turn. In addition, Mr. Harris has a habit of hogging the road. In this incident, treating Washington Street as a one-way street, stopping in the middle of the roadway, making it difficult for vehicles turning onto Washington Street. It is my allegation that it was Mr. Harris who was operating the police vehicle in a careless manner, and then to cover his mistakes, deliberately filed false charges against my daughter with his accomplice, Officer Michaleshko, who agreed by inaction to falsified report. According to sources I've read, the Freeland Corporation has its share of financial problems. I recommend that Officer Harris and Michaleshko walk the beat a few hours each week, like the old days on foot patrol, to cut back on unnecessary fuel consumption and vehicle wear and tear, and besides, they both can use the exercise. I'm giving notice of filing a complaint with the federal prosecutor. Even so, that does not preclude the council from conducting its own investigation. A question: what is a citation? It is a negotiable instrument redeemable for value. Officer Michaleshko stated under oath that before his shift starts, he fills out general information on the face of the citation and then signs them in advance. The general information includes such entries as what county and the magisterial district. Can this be proper procedure to endorse a citation before an incident takes place? For Officer Michaleshko to sign the citations in advance would strongly indicate that the particular citation book was assigned to his custody, since at the end of his shift, no other officer would be allowed to use any citations that he had already signed and were blank. It would also indicate or suggest that Officer Michaleshko anticipated pulling over a specified predetermined number of motorists per shift. On the face of a citation, there is a verity statement whereby the officer attesting to the information contained is true and correct. At the time Officer Michaleshko was signing the citation, he was attesting to an incident that had yet to take place, putting the cart before the horse, and signing a blank citation absent specific and pertinent information concerning an alleged violation incident. At the time my daughter was pulled over, Officer Harris was operating the police vehicle in question, and Officer Michaleshko was a passenger in the front seat. It is my allegation that Officer Michaleshko, unless he was sleeping, either refused to issue my daughter's citation or was reluctant under the circumstances, so then, contrary to established policy, handed his citation book to Officer Harris, who then filled in the specific information. What was the rush to judgment? Officer Harris could have gone back to the police station and issued a citation assigned to him and then mailed it to my daughter. Has this become a common practice, swapping signed blank citations as if a deck of playing cards? This could mean to artificially generate statistics as to how many citations are issued by each officer, so to aid in promotions and a pay raise. In the alternative, Officer Harris grabbed Officer Mikolashko's citation book without his consent. Otherwise, Officer Mikolashko should have issued the citation. Maybe if Officer Mikolashko filled in the citation, the spelling would have been correct and gross errors of fact would have been avoided. At least Officer Mikolashko printed information with enough force to create a transfer imprint on the chemically treated copy. Officer Harris feathered his account that the information had not properly transferred to the copy. A properly trained police officer would know that when writing a citation, adequate force is needed to make a readable copy. I want to sidestep a moment. I make a recommendation that all police cruisers be issued a basic dictionary as standard equipment because Officer Harris does not know how to spell. Furthermore, I challenge his competency because he made gross errors of fact, claiming the age of the vehicle was 16 years old instead of documenting the age of my daughter as being 16 years of age. At the time of the incident, the vehicle was 28 years old, a 1988 model. I have to wonder how many words were misspelled on the application form when Mr. Harris was seeking employment. Officer Harris did not sign the citation or co-sign. That is the main reason I've contacted the federal prosecutor. Next, you have to examine the chain of custody in regards to citation books. Unless otherwise proven to the contrary, the citation books are state-issued and purchased by the Freeland Corporation. They are like a checkbook issued to a bank to a registered customer. Through several steps, it would seem that an officer is assigned a citation book and must sign a receipt to that effect, recording the sequential numbered set that was conveyed to his custody, and be trained and competent as to how a citation is filled out. Mr. Harris violated established protocol as enumerated in the PA Code and did not state exactly how my daughter allegedly violated the section of the Vehicle Code in regards to careless driving. Were my daughter's alleged actions intentional or not? The citation was grossly defective, since Mr. Harris only parroted the language found on the heading of that section without giving details, thus depriving preparation for a meaningful defense. Furthermore, Mr. Harris failed to properly file a police report. After I submitted a request under the Freedom of Information, I obtained a copy of the scanned police report that was not properly filled out. I allege that at the time I stood before Officer Harris at the police station while he was seated behind the desk, and I requested a copy of the police report a few days later after the incident took place. A report was not completed, so we had to use a diversionary tactic to buy time, claiming I had to fill out a request under the Freedom of Information. He made the comment that no one has ever requested one before, and I replied, there is a first time for everything. Speaking of careless driving, Subpart A is an undefined act, since no definition exists in Section 102 of the Vehicle Code. It is described as careless disregard, and likewise that phrase is not defined. From examining the evolution of the Vehicle Code starting in circa 1902, to help boost municipal funds, especially during the Great Depression, at the expense of exploiting the motorists, the language of the Vehicle Code became more and more vague and ambiguous, while the courts only compounded the vagueness with more vagueness and theoretical philosophies. It is my allegation that the legislature has unlawfully delegated authority to the police officer to arbitrarily decide what that phrase means, only limited to their imagination. Get caught picking your nose for a second would be sufficient grounds. Yes, the officer can be inventive if holding a beverage or reaching over to change the radio station. The possibilities are endless to issue citations in the pursuit for some quick cash. Did Officer Mikolashko violate federal or state law, including any other statutory provisions, when he allowed Officer Harris to fill in the particulars on that citation? Was Officer Mikolashko incompetent and or disabled in some way that he could not fill in the specific information, and also being a witness? A citation book is issued to a particular officer, the same as a sidearm and badge or any other issued accoutrement. Did Officer Mikolashko also hand over to Mr. Harris his badge so to fill out the citation under his signature? Only after I noticed that two different writing patterns were apparent on the citation did Officer Harris admit he filled in the particulars on the citation. By the way, which of the two officers submitted the citation to the magistrate? The one who signed or the one who filled it out? That poses a problem, for either way, that citation would have had to have accompanied with an attached affidavit. Another point to mention is that at first glance, both officers look like twins. Besides being in the same uniform, both are bald and are without hair, and both have the same large, blubbery stature. The day after the incident took place, about 12 hours later, I arrived at the police station and asked Officer Harris who was operating the police cruiser. He said he didn't remember and would have to check the log. He led me to believe that it was Officer Mikoleshko who had issued my daughter the citation, when in fact he was the one who had the citation in his hand while Officer Mikoleshko was standing off to the side behind the police cruiser. This one time I will let my emotions cloud the issue, and with a sarcastic flair. I would like to know the name and address of the Humpty Dumpty Police Academy these two officers attended. It is my allegation that for Officer Mikoleshko to allow another officer to fill in the specific information is a violation of the Securities Exchange Act and the Universal Commercial Code. If that is proven to be correct, then I make a formal request that both Officers Harris and Mikoleshko be fired or be allowed to resign. How many other times has such forgery taken place? Why did it take two officers to fill in one negotiable instrument? And speaking of negotiable instruments, the Freeland Corporation has delegated authority to its corporate employees to issue several types of negotiable instruments in the form of parking tickets and code violations, having a QSIP number and the amount tallied. Keep that in mind. Corporate policy only applies to members of the particular corporate society. Any alleged violations are the result of infractions of the corporate policy known by the archaic slang name ordinances. Not to sidetrack, but prior to September 11, 1876, the Borough of Freeland was situated on the land, having a government consisting of public servants under common law. Words such as mayor and ordinances had relevance. A day later, on September 12, 1876, the name of mayor became obsolete and moot, but was retained as slang to mislead the people into thinking that nothing had changed. The appropriate title would be the executive officer. On that date, the 11th, that is when Freeland became a ship in dry dock in a sea of legal fiction and now governed by Admiralty and Maritime jurisdiction. That is why it is customary to see a fringed flag displayed in the Guild Hall, known by the generic name Meeting Hall. On a ship in dry dock, it's the members of the corporate society that are the servants to the corporation as non-paid employees, otherwise known as residents. And both paid and non-paid employees are obligated to comply with the corporate policy contained in the employee handbook, known as the ordinances. It's a ship primarily designed for trade and commerce. Trying to connect the dots, as they say, how does a corporate employee draft a negotiable instrument known as a traffic citation when the Freeland Corporation is not the direct source of this instrument? The corporate employee, the police officer, has authority to enforce corporate policy promulgated by the Freeland Corporation and can make arrests without warrant. Setting that aside, where is the specific section in Pennsylvania statutory law that grants delegated authority to a police officer of a municipal corporation to draft a negotiable instrument known as a traffic citation? Before the Freeland Corporation can erect a stop sign at a given intersection, after a traffic study is completed, the corporation has to promulgate an ordinance. Then any violations for not stopping at a posted intersection can be enforced. However, the Freeland Corporation is not barred from issuing its own negotiable instruments, such as with parking meter violations, and the officer has to use a negotiable instrument issued by the Freeland Corporation. Even though the Freeland Corporation has passed such an ordinance in regards to stop signs or speed limits, it is barred from issuing its own negotiable instruments, but the corporate employee, the police officer, must use negotiable instruments issued by the parent corporation, the Commonwealth. A very important question: did the Freeland Corporation pass an ordinance to adopt the vehicle code within its land boundary jurisdictions? Case in point is the limited adaptation for traffic control devices as a general category. A stop sign cannot be erected without first having an ordinance authorizing placement. Through the named ordinance and its corresponding identification number, that allows a municipal police officer to pull over a motorist if it is suspected that the motorist failed to comply with that traffic control device. But through a cross-reference, only the corresponding section of the vehicle code can be used. In regards to my daughter, where is the ordinance that the Freeland Corporation adopted the section regarding careless driving? This might be a blunder. A state trooper would not have such an obstacle because they are a corporate employee of the parent corporation, the Commonwealth. So far, I am unable to connect the dots as to how a municipal employee, known as a police officer, has been delegated authority by the parent corporation, known as the Commonwealth, to draft the negotiable instruments known as a traffic citation when no ordinance of record exists. There are sections in the PA Code that speak of general police officers issuing generic citations and what information must be contained therein. Yet there is no footnote that links this practice to a specific section of law that delegates such authority. It is just assumed by inference, as if based upon urban legend or myth created at the police academy. So, that means deception is afoot during a traffic stop when the officer, either knowingly or otherwise, has to lure a motorist into a unilateral contract to obtain joinder. Attention has to be centered to the subtle nuances of the game, and the need for the police officer, by trickery, exploiting the motorist's ignorance, to have the motorist willingly surrender the driver's license during a confiscation process as property. I have a separate video on my YouTube channel that discusses joinder during a traffic stop. As a disclaimer, we need the police, but we need peace officers, not corporate officers. When was the last time the officers in question have had a psychological exam, or even a physical exam? It is a matter of public record that Officer Mr. Galeshko has had issues in the past and had attempted suicide while employed as an officer. From observing one episode, it is my position that Mr. Harris is suffering from work-related stress as his professional responsibilities far exceed his capabilities. Even the fact that he referred to corporate property as his vehicle gives evidence that he is unable to distinguish his surroundings. As mentioned, when seeking employment, I'd like to know how many words Mr. Harris misspelled on his application form. Is that a requirement to be a police officer, knowing how to spell? Unless the word manner, M-A-N-E-R, is police jive talk or some unpublished acronym. In general, the position of a police officer should not be a career platform so that a man or a woman, especially a man, has a chance to relive fantasies, childhood fantasies wearing a costume and pretending to be a superhero. Maybe a comic book hero can act as the bully monster, but in the real world, the police officer should act professional and be able to keep emotions in check. When an officer places a badge on his uniform, he has to be reminded it is not a steroid patch. In closing, where did this religious cult pop out of the woodwork, known as the Fraternal Order? It should be disbanded since it functions as a secret society, now having a mark of heraldry, the gray flag with the thin blue line, a skid mark for traitors that hide behind a badge while they dishonor their oath to the Constitution, both state and federal, upholding their pledge to the band of brothers, and blatantly lie if necessary to protect the Klan. If the respective police departments want to form a union to have solidarity, that is fine and dandy. My daughter, a young operator who just passed her so-called driving test, was traumatized by Mr. Harris. Her exact words, she said, "Dad, the police are liars." It is my opinion that the police are not only given immunity from lying, but encouraged. They have no affirmative duty to speak honestly to one either detained or arrested, and yet if a motorist provides false information, that is a crime. The police are trained as to the proper way to falsify a report or citation, and with a little coaching can become crafted word magicians. The police have their flashcards at the ready with all the pre-chewed words and phrases on the approved list. There is the deadly device, added to the oldies but goodies such as disorderly conduct. But not to worry, the flashcard that has worn edges is the one that says level of training. For they sure know what that green leafy substance looks like when they see it, but fail to distinguish a cell phone from a weapon. Possessing such a level of training that if someone is video recording across the street, that individual is threatened with obstruction for holding a distractionary device. Orwellian newspeak is trending in the police academy, and the oxymoron. At one time, a police officer was hiding in the bushes on stakeout, but now they describe what is taking place as stationary patrol, mastering the art of moving and standing still at the same time. The vehicle code is seasoned with such oxymoron terminology. If a motorist is lying in the back seat, with the engine turned off, with the vehicle pulled off the road, a DUI citation can be issued because that motorist was in stationary travel. A revenue junkie's oxycodone is the oxymoron. Mr. Harris had the option of issuing my daughter a warning if in fact she did something wrong, absent injury or property damage. Mr. Harris failed to mention if it was intentional or not. I mentioned that before. So Mr. Harris wanted to be the tough guy and bully a little girl who happens to be my daughter. His emotions that day can be interpreted to reflect how serious Mr. Harris knew his screw-up was for almost causing an accident when he failed to stop at that stop sign. He fluffed his feathers in front of Officer Mikoleshko and my daughter to divert attention, as if to convince his partner or anyone that might be watching that he nabbed the culprit. Officer Mikoleshko's countenance that day during the traffic stop looked like as if he was a timid puppy watching what was unfolding. Another disclaimer: I have nothing personal against any police officer, including those named. For example, if any police officer were broke down along the road or in some sort of distress, I would not hesitate to stop and give assistance, as I have done in the past. I have coined a phrase called the Conant syndrome, after what took place with the Kids for Cash scandal that rocked Luzerne County several years ago. Yet the motorists are plagued with the Tickets for Cash racket. That is my allegation that the Conant syndrome was evident during the hearing before Magistrate O'Donnell as to how the matter was whitewashed. I have a separate 5-part video series uploaded on my YouTube channel. For years, the President Judge, Michael Conant, who started his career as a magistrate, felt untouchable, while so many educated members of the bar working in the courthouse for years sat back and did nothing, given how many other judges were involved. Only by extraordinary circumstances did the matter see the light of day. Then we had what can be called the Toto maneuver that pulled open the black robe of treachery. What I find ironic is that an illegal, undocumented alien or immigrant operating a vehicle without a license, without insurance, if getting pulled over, even in the land boundary under the jurisdiction of the Freeland Corporation, in many cases are simply let go, often for no other reason that the officer cannot speak Spanish, and arresting such an individual places a financial burden on the municipality. It is cost effective to let them go. But my daughter, a young white girl, now that's different, and seen as a quick means to gain some extra cash and be vindictive stating her driving record. What is the vehicle code to a police officer? It is not sacred parchment, and the police academy is not a seminary handing out missalettes. For the current publication is a masterpiece of deceptive generic terminology, and less credible than a comic book at face value, and can be described as a junk drawer containing varied topics that are loosely related. I challenge any police officer to an open debate, and we can start by defining what a certificate of title is for a vehicle, for no official definition was ever promulgated. Did you know that in 1919 the federal government made it illegal for an individual to own a vehicle as private property? Did you know that the concept of a driver's license ceased to exist after 1933 and was officially phased out in circa 1939? Did you know that what the significance to Trading with the Enemy Act of 1917, as modified in 1933 and reaffirmed in 1972, has had upon the vehicle code? Even the name vehicle code is generic. Did you know that the Vehicle Code was designed for occupied territory and implemented by the federal government when it invaded and occupied places like the Philippines, Hawaii, and Guam in the latter part of the 1800s? About 9 years before it was used in the continental United States to tax and regulate contraband? That is, now the Vehicle Code is a tool invented to commit legalized theft. Why do we need an operator's license for basic travel? Well, I should clarify that between the years 1903 to 1933, because after 1933 the ball game changed. After 1933, a motorist must sign a unilateral contract under international maritime law. The Vehicle Code only applies to persons and not humans. It was to be known as the Motor Vehicle Code that regulated drivers engaged in commerce, but the word motor was sanitized to create a more generic terminology. What is a human? A human is a tangible living being in possession of inherent rights, as if written on the genetic code. That means before one can exercise an inherent right, they must first be in possession of inherent liability. What is a person? It is an abstract concept, a creation of the state that only exists in the fictional world of accepted make-believe and can only function with privileges. Humans were assigned a persona so as to function within the fictional world of commerce. The definition of a person, besides containing entities of fiction, such as a corporation, an oxymoron is needed to squeeze humans in the sauce by saying they are a natural person within the definition. That violates the maxim of justum generis, or of the same kind. Is a human naturally artificial or naturally fictitious? Without sorcery and word magic, the Vehicle Code would fall apart. Can a horse be defined as an oxen if both pull wagon? Yet the word driver is mutated by the use of an oxymoron to say that one traveling as an operator is also a paid driver engaged in commerce. Without the adulteration of words and phrases, the money racket would go bankrupt. The Commercial Code states that the agent is not responsible for the actions done by the principal. That means John Doe, in lowercase lettering, must be tricked into accepting the liability for John Doe, in all capitalized letters, the commercial entity. Only by fraud and deceit can the Vehicle Code function, along with the ignorance of the stupid peasants. After 1933, no bill can ever be paid. Only can there be a debt offset, because we no longer have currency that has actual value. Only assigned value as a promissory note known as legal tender. When getting a citation, if you plead guilty, you can accept it for value and sign it with a promise to pay once the federal government starts issuing real currency again, backed by gold and silver. If you send a check along with the citation, the Commonwealth gets paid twice, with 2 debt offsets. Before a cadet enters the police academy, their mind has already been hacked. They have no comprehension that there is a difference between the real or tangible forest and the enchanted forest, for in their mind the two have been homogenized into slurry. During the hearing before Magistrate O'Donnell, I was not allowed to represent my daughter because the excuse given that I was not an attorney. That trump card saved the day and prevented me from challenging Mr. Harris's competency. For without a competent witness, there is no case. Only a card-carrying, due-paying member of the British Accredited Registry, protecting the Money Club, can represent chattel while on the foreign vessel, the courtroom, under the control of a private corporation, the Bar Association. Since I was not a member of that corporate society, standing within their venue, I was not allowed to represent chattel, my daughter, who was state-owned property, as evident with the warehouse receipt known as the birth certificate. What is the enchanted forest? It's the colors and lines on a map. Humans live on the land, and the only way a human can be in the earth, for example, is if entering a cave. Yet since humans cannot or do not live on a map, there must be some sort of transubstantiation whereby a human becomes a person and then it can exist inside a piece of fiction known as Pennsylvania. The geographic land area associated with the Freeland Corporation only exists in the imagination as accepted make-believe of legal fiction, and that imagery is superimposed on the land as if the mind is convinced both are one and the same. Using layman terminology, a corporation can be best described as a dead corpse, and that makes all corporate officers pallbearers, serving their imaginary friend. A corporation is created so that shareholders are shielded from liability. Well, that kind of concludes my presentation, and thank you for your time.